rise, vous vous levez. The International Criminal Court is now in session. L'audience de la Cour pénale internationale est ouverte. Please be seated. Veuillez vous asseoir.
So good morning to everybody in the court and the public gallery. First of all, I would like to ask the court officer to call the case.
Good morning. Yes, Mr. President. Situation in Uganda in the case of the prosecutor versus Domininik Oнгвен. Case reference ICC 0204-0115, and for the record, we are in open session.
Thank you very much, court officer. Before starting, I would ask the teams and the parties and the participants to introduce their teams, starting with the prosecutor. Officer of the prosecutor, please, Mr. Gumpert, you have the floor.
May it please you, Mr. President, Your Honours, my name is Ben Gumpert, and I am lead counsel for the prosecution in the case of the prosecutor and Domininik Oнгвен. With me in court today, Adeshola Adeboyejo, Deputy Team Leader, Julian Elderfield, Pubudu Sachitanandan, Cameron Chowdhury, Harry Cheng, Michaela Wagner, and Hai Do Duke. Thank you.
Thank you very much.
My apologies. There's a case manager as well. Last but certainly not least, Ramu Bite.
Thank you very much. I would now turn to the defense of Mr. Oнгвен. Please, could you introduce yourself and the team?
May it please your lordships. Mr. President, I am Crispus Ayena Odongo. I'm lead counsel for Domininik Oнгвен. I'm being assisted by Mr. Thomas Obos and Michelle O'Leal, assistant counsels. And in court with me, I have two case managers. I have Abigail Bridgman and Roy Titus Odongo, Ayena. And in court, your lordships, I have my client, our client, Domininik Oнгвен. Thank you.
Thank you. And now I would invite the legal representative. I would start with Mr. Cox.
May it please the court. My name is Francisco Cox. I represent 1,434 victims. My colleague and friend Joseph Manova is missing because he had some visa problems, but we are hoping he'll be able to join us tomorrow probably. With me is Sepide Tabo Bay and Megan Hertz. Thank you.
Thank you very much. Last but not least, the legal representative of victims, Mrs. Masida, please.
Good morning, Mr. President, Your Honors. The Office of Public Counsel for Victims is appearing today for the victims who have not appointed a legal representative. In court with me today, to my left, Ms. Jane Adong, counsel based in Kampala. To my right, Mr. Orcholon Naransetsek, legal officer. Behind us, Mr. Juan Pablo Perez Acevedo, legal consultant, Ms. Tamara Margitic, case manager, and I am Paulina Masida, principal counsel.
Thank you very much. Now I just want to introduce the team of the chamber. We have the legal advisor, Mr. Gilbert Bitti, the associate legal officers Silvestro Stazione, Simon Grabovec, and Sarah Raveling. So this for the record. Now we pass to the official part of this hearing. There is hearing of the confirmation of charges brought by the prosecutor against Dominic Oнгвен. The purpose is for the parties and for the participants to make their submissions on the question whether there is or there is not sufficient evidence to establish substantial grounds to believe that Dominic Oнгвен committed each of the crimes with which he is charged by the prosecutor, and accordingly must be committed or not, or partly, to a trial chamber for trial on those charges. I should now ask the court officer to read out the charges as presented by the prosecutor. However, as there are 70 charges brought by the prosecutor against Dominic Oнгвен, the document containing the charges is long and amounts to almost 60 pages. Reading it out now would take a significant amount of time, at least a couple of days, I would say. I therefore ask if there is any objection from the parties to skip this procedural step, and in particular I ask the defense of Dominic Oнгвен and Dominic Oнгвен himself whether it or she or he waives his right to have the charges read out orally to him. I note in this respect that a translation into Acholi, the language Mr. Oнгвен has declared to fully understand and speak, of the document containing the charges was filed in the record of the case. It is Annex B to filing 375, which in accordance with Regulation 31.3 of the regulations must have been notified to Dominic Oнгвен by way of personal service, and therefore he should be perfectly aware of what he is accused of. So I would like to give the floor first to the defense and then personally to Dominic Oнгвен, asking them to respond to the question if they waive the right to have it read out integrally. Please, defense of the suspect has the floor.
Mr. President, considering the amount of time this is likely to take and the fact that we have the full content of the charges, we have no objection to waiving the necessity to have it read out. Thank you.
Thank you very much. This is very helpful. And I now ask Mr. Oнгвен if he is fully aware of the charges the prosecutor presented against him, and if he was notified the charges in the language he fully understands and speaks, meaning Acholi. Mr. Oнгвен, you have the floor.
Bab apoy le dit non ko dong ani tung bara ange ne kari kwan nyo pegi kwan weng no chwa lo kar no pien I wi lo li enni I ram lo beach non lo chiele yeti ada ram lo mia non lo rio yeti ada chi kwan du lo enni go ba nyo ada ni non bala me kar cham ken no me yo pegi lo dul down in America look and no tear pian book and no tear come no going level chule no anberti kwan and for you
Thank you very much, Mr. Oнгвен. Nonetheless, as the reading out of the charges in open session is not only in the interest of the suspect, but also allows the general public to be able to follow the confirmation hearing, I will just summarize that in this case, the prosecutor brings against Domínik Oнгвен 70 charges. In particular, charge 1 to charge 10 concerns crimes in relation to the attack on Bajule's IDP, internally displaced person camp, on or about 10 October 2003. Charges 11 to 23 concern crimes in relation to the attack on Odek IDP camp on or about 29 April 2004. Charges 24 to 36 concern crimes committed as part of the attack on Lukodi IDP camp on or about 19th of May 2004, and charges 37 to 49 concern crimes in relation to the attack on Abok IDP camp on or about 8 June 2004. The crimes charged as part of these attacks are the following: attacks against civilian population as such as a war crime, murder as a crime against humanity and as a war crime, attempted murder as a crime against humanity and as a war crime, torture as a crime against humanity and as a war crime, cruel treatment as a war crime, other inhuman acts as a crime against humanity, enslavement as a crime against humanity, outrages upon personal dignity as a war crime, pillaging as a war crime, destruction of property as a war crime, and persecution on political grounds as a crime against humanity. Charges 61 to 68 concern sexual and gender-based crimes committed from at least 1st July 2002 until 31st December 2005. These are the crimes of forced marriage as inhuman acts as a crime against humanity, torture as a crime against humanity and as a war crime, rape as a crime against humanity and as a war crime, sexual slavery as a crime against humanity and as a war crime, enslavement as a crime against humanity. Finally, charges 69 to 70 are, respectively, for conscription of children under the age of 15 into an armed group, and use of children under age of 15 to participate actively in hostilities as war crimes committed between 1st of July 2002 and 31st December 2005 in northern Uganda. Maybe you have noticed that I skipped the charges from 50 to 60. This is because these charges have been presented by the prosecutor on a confidential basis. In filing number 381 confidential of 23 November 2015, the prosecutor submits that this is a protective measure required under Article 68 of the statute and Rule 87 of the Rules of Procedure and Evidence. The defense responded in filing 386 confidential on 4th January 2016, submitting that it does not object to keeping these charges confidential for the purpose of the confirmation of charges, but that should the charges, and I'm always referring to the charges from 50 to 60 of the document containing the charges, should these charges be confirmed, it will argue that the continuation of this protective measure would violate Domininik Oнгвен's right to a fair and public trial. The chamber, who has the ultimate responsibility on security issues and protective measures, agrees on the security assessment of the prosecutor and accordingly has accepted the filing of a public version of the document containing the charges, wherein all references to the charges from 50 to 60 have been redacted. It also accepts that the submissions of the parties and participants at this hearing concerning these charges from 50 to 60 be made in closed session. This is to avoid any possible risk that would be unwarranted at the stage in which it is yet to be determined whether there will be a trial on these charges or not. However, I inform you already that should the chamber decide to confirm charges from 50 to 60, it will be the chamber itself in its decision under Article 61(7) of the statute to make public these charges either in their entirety or with the appropriate reductions to the identity of the concerned individuals, but this is a decision we take as a chamber and upon hearing the parties on this matter. Now, in accordance with Rule 122(3) of the rules, I should now ask the prosecutor and the defense whether they intend to raise objections or make observations concerning an issue related to the proper conduct of the proceedings prior to the confirmation hearing. This is particularly important given that, in accordance with Rule 122(4), also read in conjunction with Rule 134(2) of the rules, no procedural matter concerning the pre-trial proceedings up until now may be raised in any subsequent point, whether at confirmation or at trial, if the parties choose not to do it now before the confirmation hearing on the merits is opened. Of course, this includes any issue concerning alleged defects in the formulation by the prosecutor of the charges against Domininik Oнгвен, in the sense of formal challenges to the charges on the part of the defense, which do not touch upon their merits and do not require consideration of evidence. We have already been informed, I mean the chamber has already been informed, that neither the prosecutor nor the defense intends to raise any procedural matter. I just want the record to reflect this also concerning what I just said about the preclusive effect of any such matter being raised at any subsequent point. So I will give the floor to the prosecutor and the defense in order to confirm or not. I hope they confirm their commitment not to raise any questions.
We acknowledge the preclusive effect. We have no observations and no objections. That's for the prosecution.
Thank you very much. The defense?
My Lord, we speak with the same spirit. We have no observations and shall have no objections, Your Honor.
Thank you very much. I'm very grateful to you because this means also that the chamber, together with the parties, did a good job. I would like to emphasize. At this point, we can start with the presentations of the case from the parties and participants. Also here, just to summarize briefly, the prosecutor requested 8 hours. Mr. Manoba and Mr. Cox about 2 hours and 30 minutes. Mrs. Paulina Masida 2 hours, maybe less, and the defense from 4 to 6 hours. We have a schedule. We will hear the submission in this order in the next days until the last day of the hearing, which is next Wednesday. But there is no problem if it ends before, but I think it will not. In the same order, the final observations under Rule 122.8 of the rules from the parties and participants. So, if there is no other matter to be raised, as I think, I give the floor to the prosecutor for the introduction of the case. Mr. Prosecutor, you have the floor.
Thank you, Mr. President. I'm going to speak for about an hour now, and I will then be succeeded by other members of the team. That may take me fractionally over the projected break at 10:30. I'd ask the court to permit me to finish these remarks, these submissions.
Break is at 11.
It's 11. In that case, I've miscalculated. I'm grateful. But it's still an hour. I've simply misspoken the time. I would ask the court to permit me to finish and take the break when that occurs.
But if we have an hour and you speak an hour, it should quite be perfectly in time.
More or less.
Okay, okay.
For well over a decade, until his arrest in January of 2015, Dominic Oнгвен was one of the most senior commanders in the Lord's Resistance Army, the LRA. The LRA is an armed group. It came into being in northern Uganda in the late 1980s. It aimed to overthrow the government of Yoweri Museveni, then, as now, the president of Uganda. The prosecution's allegations against Dominic Oнгвен concern his conduct between July 2002 and December 2005. During that period, there was regular combat between LRA fighters and Ugandan government troops. But this was not just a civil war between people in uniform. Far from restricting itself to attacks on Ugandan armed forces or other branches of the authorities, the LRA attacked ordinary civilian citizens who wanted no more than to be allowed to live their lives in peace. It ambushed civilian vehicles driving along the roads. It attacked and burnt the camps into which villagers had been forced as a protection measure because of earlier attacks. It looted the food, clothes, and other basic necessities which its victims needed to survive. It killed and wounded innocent people who had no interest in the violent power struggle the LRA was engaged in. It enslaved the survivors to carry away the loot and to serve as child soldiers and sex slaves. Many of the crimes alleged against Dominic Oнгвен were committed between October 2003 and June 2004 as part of a series of attacks on camps in northern Uganda. The prosecution case is that these camps were targeted because the LRA viewed the civilian inhabitants of northern Uganda as their enemies. In truth, the LRA thinking was very simple. It was a case of, if you're not for us, then you're against us. Any civilian who was unwilling to support their struggle against the government was to be regarded as an enemy. And it was the LRA's policy to kill its enemies. A formal report provided to the prosecution by the Ugandan army details attacks on the civilian population between July 2002 and August 2004. That's just part of the time period covered by the offences of which the prosecution is providing evidence to this chamber. But in this time alone, in just 10 northern districts of Uganda, 712 separate attacks on civilian targets are recorded. These were persecutory attacks, and they had a devastating effect upon the ordinary people of northern Uganda. In the course of this hearing, the Chamber will receive detailed accounts of 4 separate attacks in which Dominic Oнгвен was intimately involved. He bears significant criminal responsibility for the attacks in 2003 and 2004 on civilian displaced person camps at Pajule, Odek, Lukodi, and Abok. These were terrifying attacks. Large numbers of the civilian inhabitants of these camps lost their lives in what were often indiscriminate acts of murder. Some were tortured in various cruel ways. Hundreds of them were abducted and forced to carry away the loot. And if they couldn't walk fast enough, they were beaten and killed. Nursing mothers whose babies slowed up the progress, or who simply cried too loudly, saw them killed or thrown into the bush and left behind. A decade or more ago, when these attacks occurred, the use of camera phones was still in its infancy, particularly in locations such as these camps. The prosecution is not aware of any video footage taken during the attacks themselves, but the prosecution is in possession of video images taken by the Ugandan authorities shortly after the attack on Lukodi in May 2004. It's helpful to appreciate fully the ferocity of these attacks to view some part of this footage. I have to warn that the subject matter involves images of dead bodies and other disturbing material. But I want to play a short extract of that video now. It should be appearing on the screens